Hello, I hope you are doing well. My name is Jacqueline Vino from Galasso Learning Solutions, and welcome to the Genuine Learning blog. We have a really interesting topic that we are going to discuss today, which is noncompliance with employee retention tax credits. NOCLAR with ERTCs puts auditors in a very uncomfortable position when clients are taking advantage of tax credits that they are actually not eligible for. So what we are going to discuss today is specifically what is causing this noncompliance with ERTCs, as well as what auditor considerations need to be made as a result of this. So with that being said, let's go ahead and get started. So just to give some background on this issue, earlier this week, the Office of Chief Counsel at the IRS issued a memorandum basically supporting what auditors have been saying all along, that there have been some non-compliance going on with ERTCs at various clients. So the memorandum provides responses to various scenarios that employers have been trying to make to take advantage of these tax credits, even though they are not actually eligible to receive the credits and they don't meet the definition of an eligible employer. So overall, this has been causing a huge problem for auditors as their clients are, one, not complying with the applicable laws and regulations, and two, this is also causing some revenue recognition issues. And just to give some background, the Employee Retention Tax Credit is actually a U.S. federal tax credit that was available to certain employers resulting from the COVID-19 pandemic. So what it did is it allows eligible employers to take credit against employment taxes for each calendar quarter for an amount equal to 50 to 70% of the qualified wages with respect to each employee. So it's 50% for all quarters of 2020 and 70% for the first 2 quarters of 2022. And the code also mentions that an eligible employer could actually be an employer who had to either fully or partially suspend operations due to a supply chain disruption. However, this is a very narrow exception. You can only take advantage of this supply chain disruption exception if there are orders from the government to fully or partially suspend operations. So a supply chain disruption on its own does not actually matter unless there is an order from the government to suspend operations. And the problem with this is that almost everybody experienced some type of supply chain disruption during the pandemic. And these entities are even being advised by third parties that they are eligible to receive tax credits, when in reality they are not eligible simply because they experienced some type of supply chain shortage. So unfortunately, supply chain disruptions on its own does not make you eligible to receive any type of tax credit. So you must have an order from the government to partially or fully suspend operations as a result of COVID-19. And another thing that this memorandum provided was various scenarios and examples of the types of requests that employers were making to receive the tax credits. So for an example, this is scenario 1 that is in the memorandum. The employer was not subject to any government orders to limit operations. However, during the pandemic, they experienced some supply chain issues from a supplier. However, the employee was able to continue operations because they had a surplus of goods and they did not have to suspend their operations. Also, the supplier never provided a governmental order and the employer could not locate one. So, is this employer considered to be an eligible employer to receive the ERTCs? The answer is no. They do not meet the definition of an eligible employer because there is no governmental order to suspend operations. Also, even if they did have a governmental order from the supplier, the employer did not have to partially or fully suspend operations because they had that reserve of critical goods, allowing them to continue business. So if this employer took advantage of the ERTC, it would be an example of noncompliance. So what are some considerations as auditors that we need to make in response to this? The first one is non-compliance with the CARES Act. So in the context of the CARES Act, if an employer knowingly or recklessly claims the ERTC without meeting those eligibility criteria, it would be considered a case of NOCLAR. So the employer's action of falsely claiming the tax credits is a violation of the law and regulations. So for example, if an external auditor becomes aware of a client claiming the CARES Act tax credits without meeting the eligibility requirements, the auditor has a responsibility to discuss the issue with the client's management. And if management fails to rectify the noncompliance or fails to provide an appropriate response, the auditor may be obligated to report the matter to higher levels of management within the client's organization. So overall, this NOCLAR is causing a lot of uncomfortable situations for auditors, to say the least. And the second issue is issues with revenue recognition. So the revenue recognition issue arises when an employer incorrectly claims the ERTC despite not meeting the eligibility criteria. So in this situation, the employer may recognize the tax credit as some type of revenue on its financial statements, which would lead to an overstatement of revenue and potentially also mislead stakeholders. Also, there's always that risk that the money is going to need to be paid back, and that is also something that needs to be considered. So I am definitely excited to see how this memorandum from the IRS is going to help auditors and clients in the future. This is definitely a very interesting demonstration of noncompliance. I really hope that you enjoyed this blog today. And once again, my name is Jacqueline Vino, and I hope to see you again on a future blog. I hope you have a great day.